The facts revolve around the second bank of the United States. The nation had already chartered one during the founding. Alexander Hamilton had launched one with a 20-year charter. Hamilton and others rightly felt that a national bank was essential to commerce, setting economic policy, and tax collection. But Jefferson and the Anti-Federalists thought it was another threat to state power. That said, there was no litigation against it even during Jefferson's presidency. But the first bank's charter expired in 1811. National economic problems in the aftermath of the War of 1812, though, prompted Congress to pass similar legislation in 1816 to create the Second Bank of the United States. Welcome back to Law Dogs. I'm your host, Jeff Henley, and with me, as always, is Annabelle. Now, today we're talking about McCulloch versus Maryland, or the Great Bank Case. So here's what happened. The states passed legislation to stick it to the bank. Some of them tried to tax the bank, others tried to interfere with its operations, because the states wanted to maintain their own monopolies and prevent any sort of federal power being asserted over it. One such state was the state of Maryland, which passed a piece of legislation that imposed a severe tax both on the bank itself and then fines on bank officers who operated without paying the tax. So the United States Bank operated a branch in the state of Maryland. Soon thereafter, the state attempts to tax the bank and impose fines on McCulloch, who's one of the bank officers. So suit gets filed in Maryland State Court, and McCulloch and the U.S. Bank predictably lose. So appeal is then made to the U.S. Supreme Court on a couple of questions. Whether Congress had the power to establish the bank in the first place, and whether the state of Maryland had the ability to tax it. The first question was, does Congress have the power to have a federal bank? Nowhere in the Constitution does it say, the Congress shall have the power to charter a bank. That, of course, was the position of the state of Maryland, saying, look, Congress doesn't have the express power. It's not in there. Despite the absence of an express grant of power for chartering the national bank, the Marshall Court said, look, a bank is necessary and proper to carry out other enumerated powers of Congress. Those powers include minting money, paying debts, regulating interstate commerce. A bank, it would be thought, would be necessary and proper for carrying out those enumerated powers. It was argued and concluded. Now, you will recall that we talked about the necessary and proper clause, and that is the residual clause in Article 1 that says, look, Congress shall have the power to do what is ever necessary and proper to carry out those tasks. Now, the state of Maryland took the position that necessary meant like absolutely necessary. That is, in order for the government to exist, it had to be this way. And Marshall said, whoa, hold up. That's not what necessary means in this context. Necessary and proper means not only, but can and will make these things happen. Moreover, John Marshall said, look, it's not for the court to decide what is necessary. That's to be left up to the legislature, to be debated, to be talked about, to be argued amongst themselves. But it is up to the court to determine, does this violate the Constitution? The court concluded, look, we may not want a bank. We may think a bank is not necessarily a good idea, but Congress has the power to decide that for itself. And in this particular case, he pointed out, look, it was done for 20 years before with the first bank, and things went pretty well. People liked it. It helped. It helped the country expand. It was a source for economic continuity and stability, and thus it would be easy to understand why such an institution would be necessary and proper for the federal government. In giving his explanation for the necessary and proper clause, Marshall made one of his most famous statements. Let the end be legitimate. Let it be within the scope of the Constitution, and all means which are appropriate which are plainly adapted to that end, which are not prohibited, but consist with the letter and the spirit of the Constitution, are constitutional. So Marshall answers the first question, right? Is the bank constitutional? Yes, it was necessary and proper to carry out other enumerated powers of Article 1. But what about the second question? Can Maryland tax it? And the answer, of course, was no. But here's how Marshall got there. The Marshall Court analyzes Maryland's statute. Now, the statute actually had an onerous provision that required the bank to pay some $15,000 at the time just for a license. And in that time, that would have been about $300,000. And if you didn't pay the license, there were certain fines that could total several thousands of dollars a day. Marshall concluded, no, you can't do that because you're going to be taxing the bank out of existence. In one of his most famous utterances, he said the power to tax is the power to destroy. Even if the state of Maryland says, no, we're not going to destroy the bank, we're only going to tax it somewhat or just a little bit. The Marshall Court said, no, that doesn't matter because in order for you to be making that determination, that would mean that you, in essence, are a co-sovereign, and you are not. The states are absolutely inferior to the federal government, and thus they cannot be given the discretion of whether or not to tax something out of existence. To give them that power, to convey that power to the states, would be a denigration of the federal power. As a result, they are going to be denied such a power. Otherwise, the national government would have to just rely upon the good faith of the states not to do so. McCulloch versus Maryland, Gibbons versus Ogden, and some of the other landmark decisions of the Marshall Court were essential to building a strong national government. As you will see in lectures forthcoming, they were also essential in determining the power and the scope of the Constitution itself. If you have any questions about McCulloch versus Maryland or other decisions of the Marshall Court, email us at LawDogs. Annabelle and I will see you soon. I'm Jeff Henley. You stay out of trouble or the Law Dogs will get you.